Good afternoon, everybody. My name's Carl van der Merwe. I'm Sales Director at EB-5 Coast to Coast. I'm joined by my colleague Q Sadru, and we are very happy to have an expert attorney with us today, Brandon Meyer, who's the managing partner at Meyer Law Group. We're just going to discuss some topical things in EB-5 at the moment, and get some great insights from Brandon. So we're going to keep this in a very sort of conversational Q&A type format. And I think, Brandon, maybe if you wouldn't mind just kicking off, introducing yourself and your background in EB-5, although most people know you, but I think that would be helpful if you wouldn't mind.
Yeah, thank you, Carl. Thank you, V. Thank you, Q. Thank you, and to those of you at home or at work that are watching this presentation. So my name is Brandon Meyer. I'm the founder and managing partner of Meyer Law Group, an immigration and nationality law firm headquartered in San Francisco with additional offices in New York, Charlotte, North Carolina, Ho Chi Minh City, Vietnam, Guangzhou, China, and other places. And so myself, I've been working in the EB-5 space since 1998. I've been broadly and deeply involved in the industry, seen its growth, its crash, and its rebirth here, and pretty much every cycle in between. So I'm excited, looking forward to speaking with you today about EB-5.
Thanks, Brandon. I think we may as well start off with the most topical, something that's most topical right now is the grandfathering date, September of this year.
Yes.
I mean, maybe give us your thoughts on what that really means from a practical perspective, in terms of, yeah, please go ahead.
Yeah, so I have a little bit of a heterodox opinion in the industry about this so-called September 30th, 2026 grandfathering deadline. But before I get to that, the concept was when Congress was drafting the Reform and Integrity Act in March 2022, there was always this question about, well, what happens to investors who are still pending, that are somewhere in the EB-5 system, if and when the program isn't renewed again after September 30th, 2027. This was an issue during the last cycle when the previous EB-5 program expired. There was no specific mechanism for what happened to, investors. So a lot of investors' petitions were just held in abeyance for the 9 months where there was no EB-5 regional center program. So Congress came up with this so-called grandfathering concept, which said, okay, the program actually expires September 30th, 2027. But if you submit your EB-5 prior to September 30th, 2026, then your EB-5 will process to its conclusion, regardless of whether the EB-5 program is renewed in the future. And also, if someone changes the rules on EB-5 in the future, as long as you're in the system on or before September 30th, 2026, you will be exempt from those changes. Okay, this is somewhat important and significant. However, it's kind of been transmorgified in the overall EB-5 industry, and it's taken on a life of its own to basically be spread around and say, okay, EB-5 ends on October 1st, 2026. That's not the case. That's not true. This is just a technical deadline to ensure that, regardless of what happens to the EB-5 program in the future, that your EB-5 matter is unaffected. EB-5 program, to me, the more significant deadlines in EB-5, number one is the January 1st, 2027 increase in the investment amount. We don't know yet. We probably won't find out till October or November this year what the new investment amount will be. Probably $900 or maybe even $925,000. It is coming. We'll see it. And then also the overall program expiration as September 30th, 2027. So any sort of fear-mongering out there about EB-5 ends after September 30th, 2026 is simply not true. The program's good until September 30th, 2027.
Okay, so this is a little bit unusual, Brandon, because I remember before, right, when the EB-5 program was expiring, quote unquote, people could file until the very last day and kind
Oh
of
yeah,
were grandfathered into that old system, right? So
that's
this
right.
is kind of it, I think it's confusing a lot of people in the industry or just, investors as well,
Oh
in
yeah,
terms of
absolutely.
like what do we do during these lap months, right? Like leap months or whatever you want to call them. I don't,
Keep doing
September
what we
till the other year, it's a year.
Yeah, we keep doing what we've done in previous times,
But
which
what
is
happens to those investors? Is there any clarity? Like if an investor goes into October 1st or October 2nd, what happens to
Mhm.
them?
Yeah, well, part of this, and there are discussions ongoing right now about renewing the program and renewing the program early. And during these discussions that have been kind of happening through back channels in DC and elsewhere, one of the issues that um, Congress feels it needs to resolve is this grandfathering issue. What they meant by grandfathering was they saw it as helping the EB-5 industry as a way of smoothing out demand over a 12 to 15, 18-month period by creating these various milestones. They didn't realize, Congress didn't realize, Senator Grassley's office didn't realize that this actually, for better or for worse, rightly or wrongly, has created a panic in the industry. That was not their intention. Their intention was to smooth out demand and encourage people to file early, as opposed to what's typically happened in the past, where
Right,
everyone,
the
where
last day.
last day or large numbers of people file in the 6 months prior and effectively crash the system for years to come. And so I wouldn't. I would be cautiously optimistic that one or both of the following will be resolved sometime between now and the lame duck Congress of January 2027. One would be resolving the ambiguity around this grandfathering clause, and number two would be, possibly an overall program extension. So I
Right.
think the issue is going to work itself out one way or the other, and in my opinion, it's an important issue, but not an existential issue to EB-5.
Right, I agree with you. But here's where I want to kind of just stop for 1 second, if you don't mind, bear with me. If I'm an investor and I'm preparing for this, right? So now
Mhm.
there is this September deadline. Um, of course, everybody's going to rush to get into September. Then what is the best advice? Like, don't apply until we get more, you know.
No, when people are ready, they should still apply, because we'll talk about these other issues, today about, like, general state of immigration in the U.S., H-1B issues, F-1 issues, age out issues, lack of movement in EB-2, EB-3 priority dates. None of those demand drivers of EB-5 are going to change. So
Right.
when people have the ability to do EB-5, they should move forward with the EB-5, and these issues around grandfathering and other are basically distractions, because the underlying issues that are you know forcing them essentially to consider EB-5 are not getting better. If anything, they're going to be getting worse over time. So
Gotcha.
demand drivers are still pushing stronger. And so what I would predict, let's just assume that, grandfathering provision isn't resolved, and we don't have a extension of the program until sometime in 2027 or even 2028. What's going to happen? I kind of see three waves of EB-5 between now and September 30th, 2027, if nothing changes. We're going to have the September 30th, 2026 grandfathering rush, which
Okay.
should be, now the Chinese New Year and Lunar New Year Tet are over. The overseas markets are start heating up here in the next couple weeks, plus the H-1B and F-1 markets here in the U.S. So we're going to see one surge between now and September 30th, 2026.
Right.
Then, okay, then October, okay, a lot of the normal demand gets pulled before September 30th. Then sometime around the beginning of November, then we'll receive word of the investment amount increase. Let's say
Right.
925,000. And then we'll have a second panic wave of people trying to get in. They won't care one bit about all that grandfathering, what that means, because this is their last chance to get in at 800,000. Why not get in at 800,000
Right.
today
that
Okay.
was basically that's kind of what I was trying to get to
Yes.
into. Like if you invest in October or November,
Hmm.
before that increase, does that mean that the regional centers would have to go back and ask you for the, for the difference between 800,000 and whatever the new price is going to be, or do you get, it's kind of confusing.
Yeah, I would think not for the November, October, November, and December 2026 investors. I don't think there's any chance they'll be subject to any new investment amount increase.
Right.
Because it's not effective until, you know. However, those people who are partial funding, and we can talk about this, definitely want to make sure that they fund their 800,000 prior to September 30th, 2026, because they don't want to find out the hard way if some officer at USCIS thinks they're subject to the higher amount. So that's one tactical consideration. And
Gotcha.
then I kind of think we'll come back in 2027. Maybe we'll all take the first 3 months of 2027 off. We'll need a nice vacation, take off January and February, and then we'll come back from Chinese New Year, Lunar New Year, and say, wow, the EB-5 finally actually disappears in 6 months, and then we'll be back on the hamster wheel again for another 6 months. So basically, yeah, I see three waves, minimum of three waves between now and September 30th, 2027, and a possible fourth wave, with that, with the sort of Damocles that is hanging over our heads, that being eventual retrogression in either rural and or high unemployment categories. And so, I mean, I know it's easy for me, it's easy for us. We're in the EB-5 business to basically say, file early and file often. But really, I mean, at this point, that's what that's what people need to do, because we have these four looming issues. Well, actually, just the four looming issues of EB-5 and all the other issues outside of EB-5, that EB-5 is the solution for most people, for better or for worse.
Yeah, thanks, Brandon. That's good advice. And I think, I mean, from a practical point of view, if you want to meet one of these deadlines, you have to start early, because in the
Mhm.
past you could always do these skeletal filings pretty
Yeah.
much, and that was sufficient, but not under this USCIS, right? You have to have a very comprehensive source of funds, and you have to start working on that weeks before you file. And so
Mhm.
I think I'm sure you're crazy busy, like a lot of top attorneys, and it's only going to get busier as you get towards September. So if someone
Mhm.
realistically wants to file by the September deadline, they're going to have to engage you well before then.
Absolutely, yes. I mean, you know, realistically, it's going to be difficult, to engage any firm who's active in this space after September 1st, 2026, if the grandfathering provision doesn't change. I mean, person would have to come to us and other firms with basically, perfect source of funds documents all ready to go, project selection all ready to go, liquidity, basically getting, the ability to go hit 800,000 on their wire transfer button like today. That's the only
Right.
way it's really going to work, because if you push it too long, then it's not only do you have the legal work capacity issues and chasing down documents, and the ability no longer, with USCIS cracking down on skeletal filings that we used to rely on in the past, but then, simple reality of finding a, you know rushing into a project selection because all the good stuff and is is sold out. And
Right.
so this is
Right.
definitely, if you're sitting here concerned about your H-1B, or you're sitting here concerned about whether or not your employer's going to sponsor you if you're an F1 and you can't find an employer to sponsor you for an H-1B, or you keep missing out on the lottery, whatever the case may be. I mean, again, it's easy for me to say, but basically the time is to accept the simple reality of the situation. And that is, other than marrying a US citizen, which, has its own significant downsides,
Challenges.
challenges, and, we can have a separate webinar on that. Really, EB-5 is really the only self-directed, most direct path toward a green card that you yourself can control.
Right. Right.
Yeah, I think that pretty much, I mean, I would suggest we skip to the discussion around the visa bulletin, because that's probably the next most contentious hot topic that we often get questions on. So I know,
Yeah.
Brandon,
Mhm.
you've had some interesting insights into that, and I mean, it's fair to say that most of the pundits have been wrong on this, but I think you've actually been on the right side of that. So um, I'd love to hear your thoughts on what do you advise people when they ask, how long do I have before the backlog?
Yeah, so that's the $800,000 question, is when is the backlog going to hit? So once all the litigation, post RIA litigation, was cleared up in September 2022, and we could start doing new filings again. My prediction, based upon what I was kind of seeing from volume and the rate of I-45 adjustment of status approvals and the rate of visa issuances overseas. In September 2022, my prediction was that we would see retrogression in sometime between June and August of 2024.
Oh.
Okay. So fast forward 1 year, summer, fall 2023, I've slow visa issuance, slow I-45 approvals. I revised my prediction to sometime between June and July and October of 2025. So I was wrong again. I was wrong twice in that regard. And in my current prediction, if and when it occurs, will be sometime this summer. But at the end of the fiscal year, August or September, and then there'll be a small blip, and then the numbers will reset themselves in October. That's my current prediction. I'm not confident in that prediction. If anything, I still think the quota is going to be open for a lot longer than we think. And so then this kind of comes this tension that USCIS publishes data about the number of 526 filings, and then you can kind of reasonably compare them to visa demand, and people come up with a number, 5 years, 7 years. Some people are out there saying 10 years. And I'm like, okay, all right, let's settle down for a second. You know, um, any kind of time estimate, any sort of retrogression estimate that someone gives you, you can immediately discount it by 30%, if not more. And why do I say that? Because all of these predictions are based upon pure straight line numerical analysis. So they're assuming 100% approvals. They're assuming visa multiples that turn out to be too high in reality. They're not taking into account what we call the 4Ds. 4Ds are denials, deaths, divorces, and dropouts. So sometime between 526 stage and you don't see too many I-45 adjustment of status denials, but they do happen. But between 526 denials, I-45 denials, and denials of visas at consular posts for whatever reason, we know that like anywhere from like 20 to 30% of people will fall out along the way historically. And we're seeing a surge in 526 denials right now. And we're also seeing posts in China scheduling more and more interviews in the coming weeks. A lot of those people probably have children that have aged out because they're cases from the 2015 timeline. This all adds visas back. This all drops demand. People unfortunately die during the process. People get divorced. People drop out. We just got a 526 approval last week. We're like, hey, here's your 526 approval. They're like, oh, we don't want to do this anymore. Can we withdraw it? Okay, sure. And so when you start adding those 4Ds, it already cuts like 30% off your estimate. And then it's not taking into account rollover visas. We don't know what the rollover visas are until Department of State tells us what that number is, which they should be telling us what the number is here very, very soon. And so I don't think the retrogression situation is going to be as dire as some people predict.
Making it to be, right?
Yeah, and
Yeah.
fundamentally, it almost doesn't matter because as we look here at the visa bulletin, what we are concerned about the most are the bottom three categories.
Right.
Fifth, EB-5 set aside rural, high unemployment infrastructure. Those all have capital letter C's, means current, so it means that there's visas theoretically available. But more importantly, as long as you file your I-526 and adjustment of status in the US while the visa bulletin's current, that's really what you want. Obviously, once you file it, you want it approved sooner rather than later, but the premium is to get it filed while it's current, because then you start accruing all the benefits of the concurrent filing. EAD work permit, advanced parole travel document, ongoing status in the US, heightened protections against age out for children, et cetera, et cetera. If it takes 5 years as opposed to 4 years, okay, do you really care? I mean, or should you really care? Probably not, because basically what concurrent filing allows people to do is live in the US as de facto permanent residents while they're waiting for their permanent residency applications to be approved. Huge benefit of the Reform and Integrity Act. And so
Absolutely.
as long as you keep seeing capital letter C's in the bottom three categories, we're good to go. But again, don't let complacency be your guide. That will change some point here in the future. We don't know when. But one of the things I do want to highlight here, I think, Carl, you were giving me the prompt earlier, is if you look for under India, if you look for under EB2 India and EB3 India, it shows us that EB3, I mean, it's kind of a false analysis. I mean, it's already like 12 and a half years behind schedule. But according to this, EB3 is nominally faster than EB2. Now, how can that be? EB2 is in a superior category, more visas. Why is it slower than EB3? And it's because there's been an oversubscription of people trying to get into the EB2 category under the assumption it'll be faster. And in the process, they've made it slower for themselves. Right. And so this becomes relevant in the discussions of, projects that are in the rural versus high unemployment areas, because I keep hearing, I only want to look at rural because rural is going to be faster. And I'm like, well, that's true, or maybe true, but if everyone piles into rural, it's going to actually end up being slower than high unemployment because you'll crash your quota a lot faster. And so I see some of that dynamic, but the good thing is that projects, it's not a unitary qualification system. A rural project can also qualify under high unemployment if it meets both standards. Obviously, a project that's in an urban area could qualify as high unemployment, won't qualify as rural, but rural projects do have the ability to qualify as both, that gives people the ability to eventually choose which line they want to have their visas, which line they want to stand in, and which line they want to have their visas charged to.
So you have to choose. It doesn't automatically.
Correct. You receive a letter from USCIS. Well, first assuming that you check the project qualifies in multiple areas, through the I-956F approval, and assuming that you correctly check the multiple boxes on the I-526E form, USCIS will issue an approval notice, and in the upper right corner, it'll have all the subcategories that the 526 qualifies for. So it'll say high unemployment, it'll say rural, whatever the case may be. Then when USCIS gets around to adjudicating the I-45 adjustment status, or the National Visa Center gets ready to start scheduling interviews, they'll send a letter out saying, hey, you qualify in multiple areas, basically pick one. And you pick the one.
Well, that's actually a really good flexibility. I didn't know that.
Yeah.
That's pretty good.
Mm-hmm.
So as you approach that, visa issuance date, you can actually change the category, if the project, qualifies for more than one category.
That's right. You choose the line that's either no wait or has the shortest wait when that time comes.
Amazing.
So it's a nice little feature. And a lot of people miss this from the beginning.
Right.
EB-5,
absolutely.
But yeah, now it's catching on.
Okay, that's interesting. Well, I think All Points North qualifies under both categories, so that's something we should point out more.
Right.
Yeah,
Absolutely.
that's how I was
Absolutely.
setting that up for you, Carl, so you can knock that one
Thank
out.
you.
There.
Okay. Should we chat a bit about source of funds? I mean, obviously the market has changed a lot under, you know, with concurrent filing, and it's moved very
Mhm.
much to the H-1B market in the US, and they have definitely have different sources of funds. And I don't know if you want to chat a little bit about that, Brandon, and what, you know, what works, what doesn't work. Or do
Yeah,
drones work? Do self-directed IRAs, are they acceptable, etc.?
yeah. So the foundation for any EB-5 is being the ability to document what we call lawful source of funds. If you can't reasonably document lawful source of funds, then the EB-5 basically falls apart at the beginning. So this is, probably the most critical element of any EB-5 process is documenting source of funds. And so, we've seen evolution over time over what people um, are providing as their source of funds. And then different markets, different countries have different sources as well. For example, in Vietnam, most if not everything is sourced to the sale of property that people obtain. In the US and in the H-1B market, this is something that's kind of changed in recent years as well. Pre-RIA, we saw a lot of people that were getting a significant portion of their EB-5 investment from gifts from parents. And so, so then the responsibility was to prove for the parents to prove their lawful source of funds in order to make the gift. And that somewhat has changed, say, between 2018 and 2023 going forward. And so now we see we see this, especially in the H-1B market, this whole kind of menu of options that people are throwing together, and less gifts from the parents overseas. And I'm starting to think that that's not really. I mean, okay, I guess like who wants to be indebted to their parents forever for bringing them to this world, educating them, and then still giving them the money to do U.S. green card? I get it, but why do I bring this up? Because prior to 2022, the number of people that we saw using retirement funds and self-directed IRAs was around zero. Like no one did it. Project loans, no one did it. Why? Well, why? Because they didn't really need to do it. Okay, granted, it was 500,000, but the option wasn't there. And so, kind of some bright sparks in EB-5 in late 2022, early 2023, started coming up with these project loans and these, you do 401k loans and do self-directed individual retirement accounts to your project. And okay, and USCIS was kind of okay with these at first until they weren't, and now they're not. And now, is it fair that USCIS went from approving a lot of these to, without warning, summarily denying some of these or issuing, lengthy requests for evidence? Of course it is. And so, why are they doing it? I mean, they don't talk to us, so we're only speculating. But my speculation is that they realize that like people are using 401k loans and self-directed IRAs as a hedging strategy. It's not real cash in their mind. 401k, yeah, you can cash it out early, but it's not available to you until you're 59 and a half. Same with IRAs, 59 and a half and 65. So basically, I think a lot of people, the idea was put into people's heads, hey, hedge on these things by using your IRA, using your 401k, taking project loans, whatever the case may be, so you don't have to dip into the real cash you have. And I think that's starting to backfire on people. And so
Even
why
the self-directed IRAs, like
that's
if
correct.
someone is doing partial funding with that,
That's correct. Yes.
so you're seeing denials on that?
Seeing I'm hearing of RFEs on that. I haven't seen any, at least I can't recall hearing or seeing any denials yet. Um, and that's more of a partial funding issue. So let me cover the partial funding issue as well, because it all kind of ties together, because we're
Right.
seeing more of this. Like, I want to have my buddy lend me $100,000, and then I'm going to do a $50,000, 401k loan. Then I have 200 in my self-directed IRA. And then, I want to do partial funding because, I'm going to hit the lottery next year, or whatever the case may be. And, again, prior to the Reform and Integrity Act, a number of partial funding cases out there in EB-5. The only time you ever saw them was like if people emerged to do EB-5 like a day or two before a deadline. And then we're doing the skeletal filings that, Carl was referencing in the past. And we had one that the guy funded, $5 partial funding prior to a deadline date. And I think USCIS sees all of this, and they're like, these guys are basically just they're just hedging. They don't really want to put up the 800,000, and so this is wasting our time by getting these kind of half-baked source of funds. Okay, let's just deny them all, then it'll clear it up. And I think there's something to that, because the idea was put in people's heads that they could partially fund, they could use it could basically use not real cash, and it's taken on a life of its own. And I think the industry as a whole has to back up, and we're starting to see some of this and saying, if you want to do this, you want to do self-directed IRAs, you want to do partial funding, fine, but you're really taking on a lot of risk. I think a lot of the market actually does have the 800,000 in liquid or liquefiable enough cash to do EB-5. They just don't want to part with it. But if you're 35 years old and you're looking at this IRA or 401k that you're not going to be able to use for 25 plus years, it's just tempting to use that, because it's not real money in your hand. Mm-hmm. And so I think we're getting back to a situation. And then the project loans are another different issue. I had warned groups that they were really courting disaster by doing that. They told me I didn't know what I was talking about. Well, as Carl referenced earlier, turns out I knew what I was talking about, and now it's a massive mess. So now I think we're back into a situation where in EB-5, cash is king, real cash is king. And if that means that, the individuals in the F1 and the H-1B market have to go back and, receive large gifts from their parents or other family members to do EB-5, then that's what they're going to have to do. It'll lead to a much smoother process. One differentiation I want to do, I hear like, hey, my brother is going to loan me 200,000. Okay, I say, no, you can't do it as a loan. You have to structure it as a gift. Well, what's the difference? Realistically, there is no difference, but USCIS, who are the final arbiters, they see in their mind a massive material difference. If they see that I've lent V I'm friends with V, I lend V $200,000 to do EB-5, and V doesn't repay me, well, in USCIS's mind, that 200,000 is not at risk to V, because it was actually at risk to me, and I'm not the EB-5 applicant. But if I execute a gift affidavit and say, here's my 200,000 to V, it's hers, I don't want anything to do with it, here's the gift affidavit, it's a much different calculation. So now if the project fails, V is the one who's at risk of losing that 200,000 because it's hers. Now, if some point next year, next month, whenever the case may be, V says, hey, I want to, you know what, Brandon, I feel wrong taking your gift, so I want to repay you over time. Okay, that's fine. That's fine. But yeah, that's one of those mistakes I see and hear about, is like people, like they're not telling their clients that loans among friends and family members need to be structured as gifts, and it's coming back and causing problems.
That's very interesting. I kind of like in my mind, and I think in a lot of people's minds, a loan is better because you're showing commitment, But this is very interesting, the view that, USCIS takes in these cases. Now, I do have a question for you on one thing, though. If it is a loan and I'm pledging collateral to it, even though it's like a personal loan between two people, and I'm pledging, I don't know, my house or something like that. Would that strengthen the unsecured loan? I mean, this
It might,
individual
it
loan
should,
thing,
because there's now a security interest. But then you
right?
have the issue of like, how does the lender perfect the security interest and all those other issues? So that's an improvement, but I still think it's going to, number one, run into problems at USCIS. And then they'll probably come back and say, well, wait a minute, like this was the issue that some of the project lender people had, was USCIS came back and said, wait a minute, you're a builder, you're a construction company, for example. Like, where's your commercial lending license to do this? Oh, you don't have one? And so USCIS could take that in your scenario. They could take that position with you. I do think it's better than just a pure lending of unsecured loans
Unsecured
between
loan, right?
friends and family, but still, I
A
mean,
gift is best.
gift is best. No point in
Okay,
flying close to the sun if you don't have to.
got you. Right, if you don't have to. Okay,
Yeah.
all right. That's a good insight.
Okay. I mean, just in the interest of time, maybe Brandon, you're pretty uniquely positioned because you're also affiliated with a broker dealer, so you can actually advise your clients on investments,
Mhm.
and you've got your own company there called EB-5 Choice, that your own platform that you have due diligence on various projects, and so I think just generally speaking, and it's a separate whole conversation, but what do you
Mhm.
look for? What are the sort of top things you look for in terms of safe projects from your perspective?
Yeah, while past performance is not indicative of future success, it's still a pretty good indicator. And so, the demonstrable track record of the regional center and the developer in, delivering the sum total of the three following things to their investors, green card because they built the project, created the jobs, return of capital in a reasonable time, and, whatever that de minimis return on top of the investment, their track record in delivering all three is very, very good. That's really the starting point. And, so basically reputation and track
Yeah,
record and everything. And then at that point, that's how you kind of weed out groups on the front end. And at that point, then you start looking at the specific project details. And, such as, does the project make sense on its own? Does it pass the common sense test? Is it you know, um, a luxury $2,000 a night hotel in, I don't know, Topeka, Kansas, or is it, something a little more reasonable that makes sense for that particular market? Capital stack is important as well. Um, you know, um, job create. Is the project under construction? How, when where is it in its construction timeline? How many jobs have already been created? You know, you know, job creation buffer as well. Is the group trying to milk every penny of EB-5 they can out of their jobs, or are they giving themselves some margin for error? And all these things, you roll them in together, and that's what really kind of constitutes, you know, um, a good choice in EB-5.
yeah. How important do you think it is to have an approved project as well, a 956 approved? Is that
I mean, it's helpful, but the way I look at it is, it's like a lot of the groups here in EB-5 have been in this for a long time. They know how to put together an approvable F petition, or at least they should, or at least some used to, and then they push the boat out a little bit. But yeah, so a lot of times I see these as like it's not a question of if a group's F is going to get approved, but when.
right?
And
Yeah.
so it's obviously having the F approved is highly dispositive. It's already cleared immigration perspective, especially if the project's under construction. If you find a project that has F approval, there may be one that you've already reduced. Basically, know that you're going to clear the immigration process from the beginning, assuming you can clear source of funds, because project's been vetted from an immigration perspective by USCIS and it's passed. And if the jobs have already been created, your 829 will is approvable before you even file your 526. These are huge advantages. But I mean, here's the thing, especially as the market heats up over the next 6 to 18 months, if my predictions hold true, waiting for F approvals is probably not the best strategy because, you know, people have to make decisions. And so a lot of times, like, projects will sell out before they even get their F approved. Or if the F's approved, like all these people that were kind of evaluating it suddenly jump on it. So I guess the sum total, my answer is it's helpful, but it's not everything. And that's a part of the due diligence. I mean, Carl, like your group having an F pending is a lot different, standard than some small new group that's never done EB-5 before that has an F pending. So that's also a part of the reputational risk that I kind of grade someone's F pending versus approval accordingly.
Excellent. That's helpful.
I wanted to kind of, before you mentioned something about, 20 to 30% of cases will get denied or will get dropped off somehow. And I wanted to ask if, most of these cases, because I mean, when you go to source of funds, they're very few. Nobody really gets denied for source of funds, especially now with the US. I don't know. I might be wrong again, but I was wondering if these F denials go from a project, because once a project is denied, everybody in it is denied. So maybe these big numbers come from that.
Yeah, I wasn't so much thinking. That's a good point. I wasn't so much thinking about that. I was just thinking of like historical over time.
Uh-huh.
Not just our current situation, but kind of like from time beginning of like the number of people that kind of like drop out, don't make it to the finish line for.
Yeah, because I mean, 20 to 30% sounds like really big, and people might get, a
But
little
still, yeah, but still fine, because what happens to those, so like when our friends at EB-5 Capital go get their F denied, what happens is like all those, and most, if not all of those investors get moved into another EB-5 Capital project. So so it just shows up in amendment. So it never really shows up as a 526 denial in the system.
Ah, okay.
Now, USCIS, on the other hand, if they haven't denied or withdrawn the first set of filings, maybe, and this is something that I didn't talk about it. I guess I'm talking about it now. That there's a certain possibility that USCIS is like double and triple counting a lot of demand. And so
Right.
the scenario where people do amendments because they're the initial project that they invest in doesn't move forward, either because the F is denied or it just doesn't move forward and they move into another project. At which point does USCIS like adequately update their records to reflect that the first group of 526s are no longer operational and just to work on the second? And two, another factor we have as well is like, for the old China cases from 2015, 16, where the kids have aged out, USCIS and or the consulate haven't made a determination yet about age out. But yeah, a lot of these who are children then are now doing EB-5 as on their own. And so 2015, it was mom, dad, and junior. Well, mom, dad, and junior are still reflected, like asking for 3 visas, because they're, they probably haven't withdrawn yet or hasn't reflected. And then junior files his own EB-5 concurrent filing. That could be reflected in the system as demand for 4 visas when it's really only demand for 1. And so you have all of that.
That's very helpful, actually. All right. Thank you, Brandon. To close this webinar, the information was really helpful. Brandon, thank you. I actually learned a lot. I just want to kind of point out that we do have, as EB-5 Coast to Coast, we do have 2 projects right now. They are both rural and they both have the 956F approved. They're pretty good projects. One of them is in the behavioral health, so the healthcare industry, and the other one is a real estate mixed use project in California. So with that, we will close this webinar. Thank you so much for watching. Thank you, Brandon, for being here. And we wish you a great day, all of you. Thank you.
Thank you, everyone. Have a good day.
Thank you, everyone.